In Washington state, firearms can be confiscated for several reasons after an extreme risk protection order during a domestic violence arrest if you're found unlawfully possessing a firearm, or if a court determines you're no longer eligible to own or purchase guns. Today on The Right Slant, we're breaking down exactly how confiscation happens in Washington, the legal steps to get your firearm back, and 2 real Washington court cases that show how the process works in real life. Stay with me, because what you don't know can cost you your rights. Washington has some of the most structured firearm seizure laws in the country. Here are the most common ways a firearm ends up in state custody. Extreme risk protection orders, also known as red flag orders. Under RCW 7.94, a judge can order temporary firearm surrender if someone is deemed a significant danger to themselves or others. Domestic violence orders. If you're accused of domestic violence, RCW 9.41.800 allows a judge to require immediate firearm surrender as a condition of release or protection. Unlawful possession of a firearm. If law enforcement discovers you're a prohibited person under RCW 9.41.040, they can seize firearms as evidence. Search warrants or criminal investigations. Firearms can be taken as evidence related to another crime. No matter the circumstance, Washington law outlines specific ways to challenge the seizure and reclaim your firearm. That's where we're headed next. Reclaiming a confiscated firearm in Washington depends on why it was taken. But every path requires strict compliance with RCW procedures, so here's the breakdown. 1. After an ERPO law, RCW 7.94. If police seized firearms as part of a temporary ERPO, you must wait for the full hearing, usually within 14 days. At the hearing, you may contest the order. If the judge denies the ERPO or it expires, you can petition the law enforcement agency to return your firearm. You must pass a new firearm rights background check under RCW 9.41.090. 2. After a domestic violence order law, RCW 9.41.800. Firearm surrender is automatic when a court issues certain DV orders. You must prove to the court that the order has been terminated, dismissed, or expired. After that, you again undergo a full background check before retrieval. 3. If you are considered a prohibited person law, RCW 9.41.047. If your seizure was due to a disqualifying condition, like a felony, mental health commitment, or no contact order, you must petition the court for restoration of firearm rights. Once your rights are restored, law enforcement can release the firearm following a background check. 4. If your firearm was taken as evidence law, RCW 63.32 and RCW 9.41. The case must be fully resolved. You must request the release through the Law Enforcement Property Office. Again, a background check is required before pickup. Before we go deeper, make sure you like, subscribe, and hit the notification bell so you never miss a breakdown from The Right Slant. On-screen text, real Washington court cases. Books case example number 1, State versus Flannery. Facts: police seized a defendant's firearms during an investigation unrelated to gun crime. He sought their return after charges were dropped. Outcome: the Washington Court of Appeals ruled that law enforcement cannot withhold firearms once the owner is legally eligible, unless another legal prohibition exists. Why it matters: this case confirms that police departments cannot create their own delays or policies to block the return of firearms. Once the owner is cleared and passes the background check, the agency must comply. Books case example number 2, State v. McLaughlin. Facts: a man under a domestic violence no-contact order was forced to surrender his firearms. After the order expired, he applied for their return, but the county attempted to retain them under public safety concerns. Outcome: the Court of Appeals held that police must return the firearms unless the individual is still legally disqualified. Public safety opinions are not a valid reason to refuse. Why it matters: this case reinforces that Washington's firearm return process is dictated by statute, not discretionary judgment by local agencies. Once you've cleared the legal hurdles, Washington requires one last step. Heavy checkmark a fresh background check under RCW 9.41.090 to confirm you are not prohibited at the time of firearm return. You should also expect proof of identification, possible storage fees depending on the department, a retrieval appointment. The most important thing to remember is this: Washington law is procedure heavy, not arbitrary. If you follow the legal steps and you are not a prohibited person, the courts and police must return your firearm. Understanding Washington's firearm confiscation laws is the first step to protecting your rights. If you've had a firearm taken, follow the process, know the law, and don't let confusion cost you your Second Amendment freedoms. Thanks for watching The Right Slant. Make sure you like, subscribe, and turn on notifications so you never miss a deep dive into your rights.